I won't spend too much time about myself and my firm, but my name, as Philip said, is Justin Sanders. I'm an intellectual property attorney and a registered patent attorney. So we help clients really on what's called the transactional side of intellectual property, helping them identify what IP they have. Then we help them protect that IP through filing patent and trademark applications, for example. We help clients monetize that IP in the way of like helping them with licensing agreements or sale agreements, things of that nature. And then for some of our bigger clients, we also assist with what's called portfolio management. So clients that have a lot of patents and trademarks, we help them manage the renewals and help them figure out which are worth keeping, which are worth letting go, kind of trimming the fat, so to speak. Yeah, that's really what we focus on here. So just a little bit about the firm really quick. So we're what you call a virtual law firm, meaning that we don't have a physical office, just we work out of respective home offices. It's one way that we keep our costs down as far as our overhead, which helps us keep our costs competitive for our clients. As far as those costs, pretty much everything that we do, we charge flat fees for those services. So we don't bill hourly like traditional law firms do. That way clients know exactly how much they're going to be spending on a particular task before they actually authorize the work. We're all seasoned professionals here. We don't have junior associates or paralegals. So when a client hires me to do something, I'm the one that's doing the work. If a client has a question, they're reaching out directly to me. They don't get handed off to anybody else. And we respond promptly to those calls and emails, which sounds like a silly thing to point out. But if anyone of you have actually dealt with a law firm before, I'm sure you know that sometimes it could take days or weeks to hear back from your attorney, whereas we get back to either same day or next business day. And so it's something we make sure we do every time without exception. So, but yeah, that's just a little bit about our firm. So in the interest of time, we'll just go ahead and move on to the topic today. And again, I want to thank Philip and the Startup Incubator at Cal State Fullerton for having me. I work with a lot of local incubators and accelerators, and I can definitely say that the Cal State Fullerton Startup Incubator is one of the best in the area, just for the level of service they provide and everything else, and the quality of mentors they have on staff. So definitely encourage you to contact them if you need help with starting up your business. So with that said, again, the topic today is just kind of a general overview of intellectual property, trying to give you that foundational knowledge as you start or continue your business, so you know when these types of issues might come up and you can take appropriate action, or at least decide whether to take action or not before you lose the option if you run out of time. So what we'll cover generally today is first we'll kind of talk just generally about what is intellectual property, or IP for short. We'll talk about the four main types of IP. We'll talk about a little bit about how IP rights are typically owned and monetized. And then I'll touch on just the 5 most common startup mistakes that I see. So hopefully you can avoid those mistakes. And then we'll end with just some general questions to keep in mind as you engage in any new or current business endeavor. And as we'll get into, I mean, these aren't questions that you're expected to answer yourself, but questions that you should bring to an attorney like myself so that we can help you answer those questions, because some of these are time-sensitive issues. And I will say too, we're going to be covering a lot of different topics today. And so rather than saving questions till the end, I encourage you just to reach out, just chime in, either type your question in the chat or just unmute yourself and ask a question as it comes up. That way we can hit those questions while they're still kind of top of mind and everything. But I'm also happy to answer questions at the end. But I will say too, this slide deck will have a lot of information in it. And just in the interest of time, I'm probably going to skim over some of it, but I wanted to have all this information in the slide deck so that you have it to refer to later. And if I skip over anything that you have questions about, again, I'm happy to stop and answer those questions, or you're always welcome to either call me or email me after the presentation at any point, and I'm happy to answer any questions you might have. So, this slide deck will be distributed by Philip after the presentation. So don't worry about having to write anything down or anything like that. So, okay, with that said, again, what is intellectual property? So generally speaking, intellectual property is the collection of rights that you have in the work product of your mind. So basically anything that you can conceive, any ideas you come up with are potentially protectable through one form of intellectual property or another. And so those things can include inventions, your trade names or symbols, which would be like trademarks, basically. Any kind of creative expressions like literary, artistic, or musical works that you might come up with, or photos that you take, things like that. Or even competitively advantageous secrets. So just information that you have within your business that you keep confidential and that has value by not being generally known outside of your company. So like a recipe, for example, or a customer list. And again, we'll get into the details of each of these examples throughout this presentation. So one of the really important things to keep in mind is while all this stuff is intangible, just these are things that you come up with in your mind, IP is freely transferable like any tangible asset. So if you ever are at the point where you're looking to sell your business or sell your company, or if you are looking to license some of your technology, anything like that, those transactions will typically involve some amount of your intellectual property. So for example, if you go to sell your business, part of what you'll be selling might be tangible assets like a physical office or computer equipment or things like that. But then you'll probably also sell your business name, which is a trademark. Or if there is any proprietary technology within your business, you might be selling that as part of the sale of the business. And so all of those things are freely transferable, and oftentimes are some of the most valuable assets that you'll have in a business. And so that's one of the main reasons why it's important to protect these assets, because if you don't, then the value in your business could significantly be affected. So I kind of answered that question right now. Why protect your IP? And the short answer is that properly protected IP gives your company a competitive advantage. You're securing some amount of exclusivity where you're able to do something that competitors are not, whether it's some particular proprietary technology that you're using within your business, or even just your name, which carries a lot of goodwill and consumer recognition. And so IP is providing some kind of exclusivity with respect to certain aspects of your business. And so that competitive advantage obviously makes your company more attractive for things like potential investors or licensing opportunities or even acquisition opportunities. In other words, that exclusivity, that edge on your competition gives your business some value there. And oftentimes, if we're talking about something where it's more along the lines of proprietary technologies or methods, most investors or licensees or purchasers won't pay you for technology that isn't properly protected, because competitors could just do the same thing with you as you without any kind of consequences if you don't have those things properly protected. So why would someone want to pay you for your technology when someone else can just do it at no charge? And so because of that, oftentimes if you are in fundraising mode, let's say, and you're trying to talk to potential investors, a lot of times investors won't even talk to you unless you can tell them that your technology is patent pending, meaning you've gotten that application at least on file with the patent office. So again, these are just more reasons why it's important to at least consider your options to figure out if something is worth pursuing while you still have the opportunity to do so. So before you can take those steps of actually protecting your IP, you have to know what you've got and what can be monetized. And that's where, again, not something that you'd be expected to do on your own, but just something that you just need to keep in the back of your mind, so that as you're developing something, you should plan on speaking with a patent attorney to help figure out these issues, to see if there's anything that's worth protecting there, and then figuring out the steps to do that with your attorney. And another thing to remember too is before you monetize that IP, before you go to market with your products or services, you want to make sure that you don't infringe someone else's rights. And that's what we refer to as freedom to operate. So that's an entirely separate issue as far as whether what you're doing is unique enough to be protectable, and whether if you were to take those things to market, would you infringe someone else's patent or trademark or copyright protection? And that includes things like your business name and any other trademarks that you might be using. And I point that out because a lot of times I talk to companies and their initial reaction is, oh, we don't have any IP needs or IP issues. But every business has IP needs because every business at least has a name. And even if you're not looking to get any kind of exclusivity or formalized protection around that name, you want to at least make sure that you have freedom to operate or freedom to use that name without fear of being hit with a cease and desist letter and being accused of infringing someone else's trademark rights. So at the very least, with every business, there's always that issue. And so that's just another reason why it's important to talk to an attorney, or at least try to do some initial research on your own. And if you do find something potentially concerning, have a conversation with an attorney to make sure you at the very least have freedom to operate, even if you're not looking to protect your IP assets. So the four main types of intellectual property, and we'll go into a lot more detail on each of these, are patents, trademarks, copyrights, and trade secrets. And so just a short summary of each of these types of IP. Patents basically protect concepts or inventions, obviously. Trademarks protect the names or the source identifiers that you use when you take those concepts to market. So again, products or services. Copyrights protect creative expression. So in other words, patent protects a particular concept, and copyright is oftentimes used to protect specific iterations or implementations of those concepts. And again, we'll get into more details of what that means in a little bit. And then trade secrets would be those competitively advantageous secrets that you have within your business. Well, customer lists, recipes, methods of doing things, just any piece of information that you're keeping confidential within your business and not disclosing it outside of your company. So the big one, and the one we'll spend the most time on, is patents. And so a patent is basically a set of exclusive rights in an invention that's granted by a particular country's government for a limited period of time. So you're getting this limited monopoly, basically, in exchange for a disclosure of that invention. And what I mean by that is when you file these patent applications, essentially that application is an instruction manual on how to make and use the invention that you're trying to protect. Now, obviously, nobody could practice that invention while your patent is active and enforceable. But the idea behind the whole patent system is that by awarding these patents, these limited monopolies, governments are encouraging the disclosure and the sharing of information in order to further innovation. So that the theory is that you file this patent application, you get a patent on your invention, and now there's this publicly accessible document on how to make and use that invention, such that once your patent expires, anybody can then build upon that that disclosure to in theory make the next best version of that technology. And maybe you're the one that makes the next best version, but by awarding these patents, that's the trade-off, is you're kind of publicly disclosing and sharing those details in order to get that exclusivity. So what a patent gets you specifically is it's a right to exclude or prevent others from making, using, selling, offering for sale, or even importing infringing goods or services into the country where you have those patent rights. So it's not something that where you have to actually sell the product yourself or anything like that. It's instead just this right to prevent others from doing so without your permission. And the important thing to note too is the importation limitation as well, meaning that if you have a patent in the United States, for example, that US patent is not going to be able to stop people in other countries from making, using, selling, et cetera, an infringing product unless you have patents in those other countries, which we'll get into. But that US patent would at the very least prevent people from importing infringing articles into the United States. So it covers you in that respect. In addition to any US activities, you can also stop knockoffs from being imported into the country as well. So that exclusivity, as you can imagine, can add significant value to your company because it's keeping your competitors at bay primarily, but then having that exclusivity can also be used to attract potential investors or licensees or purchasers as well. But an important thing to remember is a patent is not a grant of permission to take your product or service to market. So in other words, it's important to remember that you don't have to have a patent in order to take something to market. That's a common misconception that I get from clients a lot, is they think that they have to actually file a patent application on their product or obtain a patent before they can actually take something to market. And that's not the case. It's only if you want to have these exclusive rights in that invention so that competitors can't copy you. That's the reason why you file a patent application and try to get these patent rights, is to have that exclusivity, but it's not a prerequisite to take something to market. Another important thing related to this, though, is even if you do get a patent, that's not necessarily meaning or implying that you have freedom to operate, freedom to sell that product, because your product or service, even if it's unique enough to get a patent, whatever combination of features you've come up with to arrive at this unique invention might be enough to be deserving of its own patent. But sometimes it's the case where a particular subcomponent of your invention might have already been patented by somebody else. And if that's the case, if you were to take this product to market without that subcomponent patent owner's permission, you could be infringing on that particular patent. So even if you're able to get a patent, it's still prudent to do this type of freedom to operate type research before you actually go to market, to make sure there's no lingering issues like this that could come back to bite you down the road. And as I've already kind of hinted at, these rights are country specific. So if you want to have patent protection in the US, you have to get a US patent. If you want patent protection in Europe, you've got to get a European patent. Australia, Canada, basically any country around the world where you want to have patent protection, you have to go through this application process. And again, that's something that an attorney would help you with. And there's ways to kind of string these applications along so that you can file like in the US first, and then the foreign stuff down the road. And we'll talk a little bit more about that in a few slides. But the takeaway for you is that these are country specific rights, and whatever countries you're interested in, you can work with an attorney to protect your invention in those particular countries of interest. So as far as what is patentable, inventions, when you boil it down, they have to comprise patentable subject matter first and foremost. And really that's almost anything under the sun. And you can see the list here as far as what is considered patentable subject matter or potentially patentable subject matter. It could be things like processes. So whether it's like a method of manufacture or a method of doing something or a method of using a particular device in a certain way. It could be machines. Articles of manufacture, so basically just hard goods, mechanical devices, etc. It could be things like compositions of matter. So if you're in let's say the pharmaceutical industry, and you come up with a new pharmaceutical composition, or if you come up with a new chemical composition, that's all potentially patentable subject matter. And also any improvements to those things as well. So I think more often than not, when you look at what's being patented, it's not brand new concepts or inventions, but it tends to be more improvements on things that have come before it. And as long as those improvements are sufficiently unique, which we'll get into in a minute here, then those improvements are potentially patentable as well. So the things that aren't patentable, they're kind of common sense, at least the first two of them. So laws of nature or natural phenomena, those are things you might discover as naturally occurring things, but you didn't invent those things. And patents are reserved for inventions, not discoveries. So you can't get patents on laws of nature or natural phenomena. The other one that tends to be a sticking point more so is what we call abstract ideas. Which we won't get into here. That could be a whole separate presentation in and of itself. But where that really comes into play is with respect to software primarily, though technically any processes run the risk of being considered an abstract idea. And I've just provided just a little bit of information here, which again, I'm happy to speak specifically to questions that people might have on, like, for example, software and whether it might be patentable or not. It's all very case by case, but these are kind of the issues that the patent office and the courts take into consideration when making that determination. So, I mean, the bottom line is that software and other processes need to be specific technical advances over the prior art. And again, I can speak more to that on specific questions that people might have either during the presentation or preferably after. So just let me know. So beyond that threshold inquiry of whether something is even in the realm of being patentable subject matter, inventions also have to satisfy these three standards. The first is usefulness, which is kind of a throwaway standard because you can really argue that any invention has some usefulness to it. I've never had a case fail based on lack of usefulness. The second standard is what we call novelty. Meaning that what you've come up with is unique compared to anything else that's come before it. And so that tends to be a fairly easy standard to satisfy as well, because as long as your invention has at least one unique aspect to it, then we're typically able to satisfy that standard. The third and the most difficult standard, though, is what we call non-obviousness. And basically, it's whether your invention is just an obvious improvement over or an obvious combination of things that have come before it, which what we refer to as the prior art. And that's basically putting yourself in the shoes of a person having ordinary skill in the art. So that's what this acronym stands for. And so what an examiner does when you file a patent application is they'll review the application. Primarily, they'll review what's called the claims, which I'll show you what that is in a second. And then they'll do a search of what's called the prior art, which is basically any publicly accessible documents out there that were out there prior to your application filing date. And so that could be what's called patent literature, meaning published patent applications and published patents, both in the US and in other countries. But it could also be just any what we would call non-patent literature. So if there is an article online or in some other publication or a YouTube video or really just anything that's publicly accessible that shows something that's either identical to or similar to aspects of your invention, that's all within the realm of what we call prior art. And so the examiner is going to search through all this prior art to try to find anything that might come close to your invention. And if they come across something that's identical to what we're trying to protect, that's where they would potentially reject the application as not being novel, what we call being anticipated by this prior art. Alternatively, if they're not able to find something that's identical to what you've come up with, if they're able to find kind of bits and pieces here and there in multiple references, if they think that a person having ordinary skill in the art, when presented with the problem that your invention solves, would have thought to combine these different publicly available teachings to arrive at your invention, that's where an examiner might initially refuse the claims as being obvious in light of this prior art. And so again, this is all case by case, and this is something where an attorney can help you figure out whether this is a potential issue or not. But just something to keep in mind as you're developing new ideas and trying to determine whether something's even worth talking to an attorney about, which I say always err on the side of being overly inclusive in your conversations with attorneys, and just talking through all of your developments to see what, if anything, is potentially patentable and worth patenting. But these are the things that an attorney would kind of walk through with you on to determine whether something is potentially patentable. And again, that non-obviousness standard it tends to be the focus of these types of determinations. And it's also important to note that these are kind of conversations or communications that you have with the examiner at the patent office, kind of back and forth. So the examiner might take an initial stance of your invention is not unique or is obvious, but you do have the opportunity to kind of respond back to the examiner and change the scope of your claims and provide arguments or explanations to kind of clarify the distinguishing aspects between your invention and the prior art. So it's not just a one shot and that's it. You have a little bit of a kind of a collaborative discussion with the examiner to try to put the case in a condition for allowance. So as I mentioned, this universe of prior art is any third-party disclosure anywhere in the world, so not just the US. And it's anything, even if it's not in a patent application or a published patent, it's just anything that's out there could be considered prior art. Another thing to point out is it's not a prerequisite to have a working prototype of your invention. That's another question I get a lot. Obviously, the further along you are in having a working prototype, the better, just because it's more fleshed out. Maybe during that prototype development, you've run into additional issues that you had to overcome. And through overcoming those issues, maybe you've developed additional features that are potentially patentable. So the closer you are to having like a final working product or prototype, usually the better your application would be. But you don't have to be at that point to file a patent application, as long as you kind of generally know how this invention is going to work to an extent where we can then describe that in words and in drawings. That's all that's required in order to file a patent application. So another really big issue that always comes up with patents is this issue of what we call public disclosure. And so public disclosure is basically any disclosure that's not covered by a non-disclosure or confidentiality agreement. So that includes conversations that you might have with people that are not part of your company. It could be things like public use of the invention or public display of the invention, even public or private sales or offers for sale, or even what we'd call public commercial exploitation of the invention anywhere in the world. And so that commercial exploitation comes into play when we're talking about things that aren't necessarily viewable to the end user. So for example, if you're in the business of selling software, usually what you're trying to patent when it comes to software is the underlying algorithms. And a lot of times those algorithms aren't accessible to the end user. They're just seeing the final compiled software, and that's what they're interacting with. But the fact that you've commercialized those algorithms through selling the software, that's considered public disclosure as well. And the same thing is potentially true for methods of manufacture and other processes that might happen behind the scenes of your product or service. If you're commercializing those in any way, that could be considered a public disclosure. And so where this comes into play is that outside of the United States, really, I say outside of North America, but really outside the United States, the rule is that you have to have a patent application filing date that predates any public disclosure of your invention. Otherwise, if you happen to publicly disclose in some way before your first application is filed, your own activities that predate your application filing date count as part of that universe of prior art, meaning that an examiner in another country could look to those public disclosure, those public activities, and then reject your application based on those activities. Now, the US is a little more lenient. They have this 1-year grace period, meaning that if you do happen to publicly disclose in some way before you get your application filed, you still have up to a year from that date of first public disclosure to still get your application filed. Now, if you wait longer than that year, then the same thing happens where your own activities that are more than a year old will count as part of that prior art when an examiner takes a look at your application. So in other words, after that, if you wait longer than a year, you're essentially out of luck as far as trying to get patents on whatever was publicly disclosed prior to your or the more than 1 year before your application filing date. Now, Canada and Mexico kind of have similar grace periods, but they're not nearly as lenient as the U.S. So, I mean, really, the rule of thumb is to try to keep your inventions confidential until you're patent pending, which means you've got at least your U.S. application filed with the USPTO. At that point, you're patent pending, and then you don't have to worry about these public disclosure issues. So if you have to disclose to someone prior to getting your application filed, particularly if you have to talk to like a programmer to help you develop software, or a manufacturer to help you actually produce the goods, anyone outside of your company, and even people within your company, have them sign non-disclosure agreements or confidentiality agreements. And because if you do that, anything you disclose to them is not considered a public disclosure. It would be a private disclosure, basically. So you're not triggering that clock if you disclose to people under an NDA. But preferably, though, just being able to file your application even before you talk to anybody, whether under an NDA or not, that's the best course of action if it's viable or feasible in your situation. And these NDAs, it's something an attorney can help you prepare, but it's also something where if you were to just go like on Google and search for something like invention, non-disclosure agreement, something to that effect, you could probably find something that you could use at no cost. And if you look at a few of them, you'll see that they're all basically, they have the same terms and the same language in them. So they tend to be fairly boilerplate. So it's something I would highly encourage you to use, whether you have an attorney prepare one for you or you just find one for free through some internet searching. Though obviously having an attorney review it is ideal, but I also appreciate that a lot of you want to be cost effective, being in startup mode and everything else. So real quick, there's different types of patents, both in the US and in other countries. We'll talk about two of them today. That's the utility patents and design patents. There's a third type of patent called a plant patent. So if you're in the business of developing asexually reproducing plants, then you can get a patent on those plants, but that's not something I do. I can obviously refer you to an attorney that does, if that's the type of patent you're looking for. But by and large, most people are interested in utility patents and design patents. And again, there's similar types of patents in other countries. So it looks like someone asked if I charge a flat fee to review a boilerplate NDA. Yeah, I typically do, and the flat fee would depend on like how long the NDA is, and if it's a short one, sometimes I won't even bill for it if it's just going to take me like five minutes to skim through, like while we're on a phone call or something. But otherwise, it might be I don't know, like $150 or something, let's say, to review a fairly short boilerplate NDA. But and again, I can speak to any specific NDAs or other questions people might have offline. So just let me know. So utility patents are typically the ones that people are most familiar with, even if you don't necessarily know utility versus design. And what most people want and what most people go for first and foremost would be what's called the utility patent. They're the broadest type of patent in most cases. And what they protect is basically the structural or the functional features of your invention, or in other words, how your invention works. And so you get roughly a 20-year term on utility patents. And here's an example of at least the cover page of what a utility patent kind of looks like, where you've got a written description. I think this one was probably about 20 to 30 pages long. So this is just the cover page. But what a utility patent does is it describes the invention in words. Basically, the different components that are in the invention, how those components are arranged, the sizes, shapes, dimensions, materials of construction, all that kind of stuff would be described in a utility patent application. And then you would typically have a set of drawings to help illustrate what you're describing in words, just to kind of supplement that description. And the most important part of a utility patent, though, is at the very end of the document, you'll find these numbered paragraphs. And it usually starts with something like what is claimed is, or I claim, and then there'll be these numbered paragraphs. And these are what we call the claims. And so each one of these numbered claims is a separate claim. And you've got what are called independent claims and dependent claims. And as the names imply, independent claims kind of stand on their own. Dependent claims, as you'll see here, claim 2 refers to another claim. So it kind of adds to whatever was recited in the claim it's referring to. And so the goal of these claims is to cover the patent, or I should say the invention, as broadly as possible, depending on what the prior art is, obviously, as well, but as broadly as possible, because the claims are what a court uses to determine whether a competitor's product is infringing or not. And essentially the way it works is that the court uses what's called the all elements rule, meaning that in order for a competitor's product to infringe this patent, that product has to incorporate every single recited element of at least one of these claims, typically the independent claims. And so at a high level, for example, if a claim recites elements A, B, and C, in order for that third-party product to infringe, that product has to have A, B, and C. And it's a little more complicated than that, but that's kind of the simple explanation. So in other words, if this product only has A and B, or A and C, or basically not all of the recited elements of that claim, this product would not infringe that claim. And so when we draft these things, we try to make sure that we're being as broad as possible and trying to cover only what we would consider the critical elements of the invention, meaning what elements have to be present in order for this product to actually function as intended, because those would be the elements a competitor would have to put into their product if they want it to be viable. And so when you're looking at a patent, again, it could describe a whole bunch of different features in the rest of the application, what we call the specification. But to determine what that patent actually covers from an infringement standpoint, you want to look at these claims. And again, that's something that an attorney can kind of work with you on to determine whether your product might infringe one of these claims of this patent. But just to have that foundational knowledge, that's what a utility patent really focuses on, or that's the important aspect of a utility patent, is those claims. And so, as I mentioned, when you draft these, you want them to be as broad as possible. But when you file the application, it's the claims that the examiner will focus on at the patent office. And so the examiner will turn up other references to try to find something that reads on what's described in these claims. And so in this case, for example, and as you may have already gathered, I mean, this is basically a batting weight to put on a bat to take practice swings. So it's this weight that where prior art batting weight sat at the terminal end of the bat, this one sits at the center of mass. So it's basically adding weight to the bat without throwing off the distribution of weight. So you can take more natural swings, and it's low profile, so it's not going to cause the ball to fly off on some unknown trajectory. And that's what the client developed here, and that's what we tried to get a patent on in this particular case. And so here's an example of prior art, just so you can kind of see what the types of things examiners might turn up. And so the examiner in this case found a similar type of device, but it was sized for a golf club, and it sat more at the terminal end of the golf club rather than at the center of mass. And there are some other differences there, but you'll also see, and we won't spend time on this, but if you read kind of the language of this claim, you can see how the examiner taking a broad, reasonable interpretation of this claim language could find similar characteristics in this golf weight, where it has a tapered inner surface and all that kind of stuff. And so that's the type of thing then where we would work with the examiner to amend the claim language to better distinguish over any prior art that might get cited, so that we can focus on the novel, non-obvious aspects in the client's invention. So somebody asked, can we work in unknown future possible enhancements to your utility claim? Not quite sure if you want to unmute yourself and clarify that question, but I mean, generally speaking, like you can definitely describe not just preferred embodiments in a patent application, but if you have ideas for future features that you might add to future versions of your invention, or if there's alternate embodiments that you think could be viable or even not viable, but if you just want to describe them in your application, you can definitely do so. And you can potentially even get patent claims around those future versions. But at the very least, by disclosing those types of additional embodiments, you're creating a public disclosure of those embodiments, so this to prevent someone else from subsequently coming along and trying to get a patent on those future versions. So you're creating prior art to prevent other people from getting patents at the very least. And you can also potentially get patents on those embodiments as well. So we won't really spend a lot of time on this. Again, this is something where we can kind of talk offline on a case-by-case basis as far as whether you file an application as a provisional application or a full-fledged non-provisional. But this is just a little bit of information on what the differences are. And again, I'm happy to answer questions anyone might have on these different types of applications.
Could I ask a quick question of you, sir?
Sure, yeah.
In a prior conference call, they talked about how Dual, one of the big companies that makes the racks on top of the cars,
Yeah.
didn't properly file their original design or utility patent, and a competitor company came up with a similar product that had a couple degrees difference and got a patent on that. How is that? Can you summarize that briefly? How that very small difference can cause you to have an issue with that?
Yeah, and I will say, I mean, that's something I always caution clients on doing as far as trying to generalize, because I do see that sometimes where clients will come to me and they'll ask, well, how come there could be 5 or 6 different patents on almost the same invention, but yet I can't get a patent on mine when mine's different from my prior art. So I mean, every case is case specific, where every application has its own unique set of prior art. And not only that, but you're dealing with a human examiner, and having a human examiner, because humans are flawed, humans do make mistakes. And so sometimes patents get awarded that should not have been awarded. And because of that, there are mechanisms to challenge the validity of a patent, even after it's granted, through what's called an inter partes review. So if you believe that a particular patent should not have been awarded, and you're aware of prior art that wasn't taken into consideration by the examiner, or if you believe that the examiner didn't properly consider the prior art that was before them, you can always challenge the validity of that patent. So if what you've described is true, that could be a situation where the patent examiner just got it wrong, and that patent should not have been awarded. But with that said, maybe it's the case where the prior art was very crowded, and that slight change of degrees was actually something that no one had thought of before, and through that they were able to convince the examiner that was deserving of a patent. They just were able to argue that was sufficiently novel and non-obvious. So it's hard to say without looking at the specifics of the case, but I mean, it does happen from time to time, and sometimes more often than I'd like to see, where patents are awarded that should never have been awarded. And then as far as Thule missing the mark, again, I mean, that happens as well, where I mean, sometimes applications are screwed up, or just filed too narrowly. and they leave protection on the table that they could have covered otherwise had they drafted the claims better. So it's hard to say what happened there, but there's a lot of variables and a lot of human error sometimes that comes into play. But all that's to say too, I mean, that brings up a good point in why it's important to have a patent attorney or a patent agent prepare these applications for you. I mean, sometimes you can get away with doing your own provisional application, which is just kind of like a placeholder application. It doesn't actually get examined. And I actually work with some of my clients where they file those provisionals on their own, and I just kind of give some guidance to keep their costs down. But when it comes time to file the full-fledged non-provisional application, you really want to have an experienced attorney preparing that for you, because the language in those claims is so critical. If you draft those claims too narrowly, then you run into situations where a competitor can just make a couple minor tweaks, and now they've worked around those claims. And so you try to save money by doing it yourself, but then you end up with a patent that, yes, you got a patent, but it's probably worth no more than the paper it's printed on, so to speak. And so it's critical that if you're going to spend any time or money trying to get a patent on something, that you spend a little more to make sure it's done right, and that it's going to provide you with a patent at the end of the day that it's going to actually provide you with some value there. But yeah, so yeah, of course. And so there's also what's called a PCT application. Again, I won't get into the details just in the interest of time, but it's just the PCT. Here's some info on just some general information, but it's a way to kind of string along some of those foreign filing decisions and costs. You can kind of push them out a little further without losing your earliest filing date based on your US application. So again, this is just foundational knowledge for you. And as you speak with an attorney to kind of help figure out what's the best course of action in your situation, you'll at least kind of know generally what a PCT application is. And again, I'd be happy to answer more questions anyone might have on these topics. And here's just some kind of general timelines. So again, assuming that you start with a US application, whether it's a provisional or non-provisional, again, preferably you're filing that before any public disclosure takes place. And then you've got up to a year to then figure out your further filing decisions. And then by sticking to this timeline, the way it works is all these subsequently filed applications are backdated and given the same filing date as your original application. And again, that's something an attorney can help you with and calendar those deadlines to make sure nothing's missed. But just so you kind of have a general idea of what the timeline looks like. So again, utility patents protect kind of functional features of an invention, how the invention works. It describes the invention in words along with some accompanying drawings. Design patents, on the other hand, protect the non-functional features of an invention, basically the way an invention looks. So if your invention has a unique look, you could potentially get a design patent on that look. And so the term tends to be about 15 years. That's the term you get in the US, and it's kind of similar term in other countries, though some can go as long as 20 or 25 years. And so here's an example of a design patent. This is on the same product that we looked at for the utility patent. In this case, the client decided to go for both, and that is a viable option. Again, it's all case by case, but if your product has both unique functionality as well as a unique look, you could pursue both, and there could be benefits to doing so. So with a design patent, there's no written description. Instead, you're literally just providing a series of drawings, basically showing the invention from every angle. So you typically have like a perspective view, like you see here, and then there'll be a front view, a back view, a left side view, right side view, top view, and bottom view. And then sometimes you might have an additional view to kind of show the product in use, just for context or for proportions, things like that. And so the way infringement works with a design patent, so with utility patents, as I mentioned, you've got the all elements rule. With design patents, what a court does is they look at the alleged infringing product, they compare it against the drawings in your design patent, and if the alleged infringing product looks substantially similar to the design patent drawings than they find for infringement. So because of that, as you can probably gather, design patents tend to be narrower in scope than a utility patent. So taking this one, for example, this design patent is on, obviously it's on the preferred embodiment, but it's got this kind of substantially cylindrical shape. It's kind of circular in cross section, if you will, and it's low profile and everything else. But a competitor, what if a competitor wanted to make this more like octagonal or hexagonal in cross section, or triangular or some other shape? The further it gets from looking like these design patent drawings, the more likely it is that they would be non-infringing this design patent. But if you had a utility patent that just kind of described a weight that sat at the center of mass of the bat, and let's say hypothetically you were able to get a claim that broad, that type of utility patent claim would be silent onto this as far as the specific shape of this product. And so if someone were to make a product that functioned the same but looked different, that utility patent could potentially still cover those types of knockoffs, and a competitor would be infringing that utility patent even if they don't infringe the design patent. With that said, though, again, design patents, they are best used to protect not just unique looking articles, but the preferred embodiment of your article or your product. So for example, in this case, having it this shape is the preferred embodiment. If it had angles on the outer surface, that's just going to cause the ball, if it contacts one of those edges, to fly off in some unknown, unexpected trajectory. And so if a competitor were to make, let's say, a triangular version of this weight to get around this design patent, well, great, but they might avoid infringement, but they're probably not going to make very many sales either, because consumers are going to recognize the fact that this is the ideal version. And so being able to protect the preferred or ideal version of a product through a design patent has some benefit there. Plus, design patents tend to be cheaper to obtain, and they can also potentially be quicker to obtain. And so in a case like this with this particular client, while their utility patent application was still pending, they were able to get the design patent granted, so that you've got some enforceable rights to stop any knockoffs while your broader rights are still pending. So again, this is all case by case, but definitely something to consider as you speak with a patent attorney. So again, I won't just in this is a time go through this. These are just the types of design patent applications that can be filed in the US and abroad. And here's a timeline kind of similar to the utility patent timeline, just for your reference. We won't get into plant patents, but again, I just wanted to provide the information so you have it. So yeah, moving on to trademarks then. Again, as I mentioned before, the trademarks are basically the source identifiers that you put on products or services that you actually take to market. So typically what that entails is, or examples I should say, would be things like your brand names or your company names. So Nike, for example, or logos. So like the Nike swoosh, for example, taglines like just do it. It could be even things like jingles. So like the NBC chimes on their little station identifier thing that they play from time to time. It could be things like product packaging or product shape. So like the classic Coca-Cola bottle shape, for example, that's protectable as a form of trademark rights. It could even be things like product color. So for example, there's an insulation company called Owens Corning, and they sell insulation that's the color pink. And they have exclusive rights in the color pink with respect to insulation. So no other company can make insulation of that color. It could even be things like store appearance and decor. So if you have a store that has a unique look to it, you can protect that as well as a form of trademark rights. So really, it's anything that's used as a way to help consumers associate you as the company behind any particular product or service. And those things are protectable as one form of a trademark or another. And the point behind trademark rights, it has obviously the benefit of giving you a cause of action if somebody else, if a competitor tries to use the same or similar mark as you in connection with the same or similar services. But I mean, what it really boils down to is it's kind of a consumer protection act, and that these trademark laws are in place to prevent consumer confusion. They don't want a situation where you've got Nike shoes on the shelf and then you've got Nike but spelled with two E's sitting side by side, and a consumer grabs this Nike thinking it's the authentic ones, but it's not. And let's say it's a shoddy product that falls apart. Now the consumer thinks that the legitimate authentic Nike is selling poor products, poor quality products. And so trademark laws are in place to prevent those types of confusing situations for consumers. So what it gets you is this right to prevent competitors from adopting what we would call a confusingly similar mark in connection with similar or competing goods or services. And that's important to note, is that when you look at these issues, you're not just comparing the marks against one another, but you're also looking at the surrounding circumstances. So namely, what are the underlying goods and services that each mark is being used in connection with? And sometimes you also look at things like, what are the marketing channels? Are they the same? Or is it the same consumers that these products or services are being marketed to? Are the consumers relatively sophisticated or not? So there's a lot of different factors that courts weigh in determining this issue of likelihood of confusion. But the two main factors are how similar are the marks and how similar are the underlying goods and services. And that's why you have situations like with the mark Delta, where there's Delta Airlines, Delta Dental, and Delta Faucet, for example. They're all the same mark, but the underlying goods and services are so different that no consumer is going to reasonably believe that one company is behind an airline service, dental services, and faucets. And so same thing would be with the mark Dove, where you have Dove soap and Dove chocolate. Again, the underlying goods are so different that there's no likelihood of confusion there. And so I mentioned that because, I mean, as you come up with a new name for your company or a product or a tagline or what have you, one of the first things you'll probably do is like a quick internet search to see if anything pops up. And if you do find something that's identical or similar, that should not be the end of the inquiry, but instead you need to kind of do a little more research to see, okay, what is it this particular company is doing under this mark? Because if it's something in a completely different space, then it's potentially not going to be an issue for you. So like if you're planning on selling clothing and someone else is using the mark in connection with cheeseburgers or something completely different, that's likely not going to be an infringement issue. But if you do find something similar, it's definitely something where you'd want to have a conversation with an attorney just to better rule out any potential issues. And similar to patents, these rights are country specific. So if you want rights in the US, you have to preferably file a US application. If you want rights in another country, you've got to file rights in applications in those other countries. So there are different types of trademarks as well. And the three most common are what we would call word marks, stylized marks, and trade dress. And so word marks are basically just the plain text characters of a mark. It's not limited to any particular stylized version or color or capitalization or anything else. It's just those plain text characters, such that if you're able to get that mark registered or protected, that word mark registration is going to cover any stylized version of that phrase that you've got covered. And so because of that, word marks are the broadest form of trademark protection that you can get. Stylized marks are, as the name implies, basically a stylized version of your name, or sometimes it could just be a logo that doesn't have any text associated with it. But so like this Coca-Cola script font would be an example of a stylized mark. If you're able to, in most cases, I should say, if you're able to register the broader word mark, usually you don't have to go through the trouble of registering a narrow or stylized mark. I mean, sometimes there are benefits to doing so, and that's all case by case, which we always kind of discuss with our clients. But word mark is typically the one you want to give priority to when trying to protect your trademark. And then trade dress is basically some of those examples that I gave where product configuration or product color or kind of store look and feel. Those are all examples of what we call trade dress. And again, those are valid forms of trademark rights as well, as long as what's being registered is something that a consumer views as a source identifier. So again, the Coca-Cola bottle example is the common one, where when you see that shaped bottle, you immediately think that's a Coke bottle. And so when there is that connection between what a consumer is looking at and the company behind it, that's something that's potentially protectable as some kind of trademark. So a mark must be distinctive enough to actually function as a source identifier. And when we talk about strength and distinctiveness, there's this spectrum that marks are judged on, where at the low end you've got what are called generic marks, or basically just the common name for the underlying product or service. So if I'm selling shoes, the term shoe is going to be generic, and generic marks are not protectable as trademarks. However, anything above this red line is potentially protectable as a trademark. And so one step above generic marks are what we call descriptive marks. And so that's where the mark describes some aspect or characteristic of the goods or services. So again, if I'm selling shoes and my brand name is Soles, a shoe has a sole to it, and so that would be a situation where the mark would likely be deemed descriptive. One step above that is what we call suggestive marks. So there's some connection between the mark and the underlying goods, but it doesn't directly describe some aspect of the goods or services, but instead the consumer has to make some kind of logical connection in their mind. So again, if I'm selling shoes and my brand name is Marathon, well, marathon runners often wear shoes when they run in a marathon. So there is some correlation, some connection there, but it's not necessarily a direct connection. And so that's where we would say that's a suggestive mark. One step above that, you've got arbitrary marks, where you take some real word and arbitrarily use it in connection with your goods or services. So again, there's a sandal company called Rainbow. Rainbow has nothing to do with shoes or footwear. It's just kind of arbitrarily used in connection with that. Or Apple for computers, where Apple is a fruit. It's not a computer, but it's still a real word, but it has an arbitrary association with the underlying goods and services. And then one step above that is what we call fanciful marks, basically when you just make up a word, like Keds, for example, or Kinkos for copies. And so the higher up you are on this spectrum, the stronger the mark is from a distinctiveness perspective, where when these marks are so distinctive that consumers, when they see those brand names, they immediately recognize them as being brand names, because there's no association really with the underlying goods. Whereas with descriptive marks, there isn't necessarily that inherent distinctiveness, that automatic association in the consumer's mind, but instead what typically happens is when a consumer sees the term Soles, they don't necessarily see that as a brand name, but they see that as a description of some aspect of the goods being sold. And so with these descriptive marks, the mark owners have to go through a little bit of kind of marketing efforts, if you will, and training consumers to recognize that name as a brand name, as a source identifier, rather than just a descriptive term. And so all that's to say is that as long as your mark falls above this red line, it's potentially usable and protectable as a trademark. And there's no right or wrong end of the spectrum to be on. It's just the higher up you go, the less descriptive the mark is of the underlying goods or services. So you tend to spend a little more money in marketing efforts to tell people that, yes, my brand name is Rainbow, but I'm selling shoes or footwear. And so that's where the money tends to be spent. And on the descriptive end of the spectrum, you tend to not have to spend as much money conditioning consumers as far as like what it is you're selling, because it's fairly apparent just based on the mark itself. But what you tend to spend money on is enforcement efforts, because the more descriptive a mark is, the higher the likelihood becomes that competitors might try to use the same or a similar term to describe their own goods, or as a mark in connection with their own goods or services. And so you're having to spend money to maintain that exclusivity. So either end of the spectrum, you're going to be spending money. It's just, what would you rather spend the money on, basically? And again, this is something that you can discuss with an attorney, and an attorney can help you figure out kind of the best way to go in your situation. So in the interest of time, we won't really talk about these different trademark rights, but there are, in the US, there are what are called common law trademark rights, where the second that you start doing business under a particular name, or the second you start providing goods or services under a particular name, you do have some amount of common law rights. So anytime you see a TM or an SM next to a brand name, that's an assertion of common law rights. And essentially what that gives you is geographically limited rights in wherever you're actually doing business or making sales. So if you're based in Southern California and you're selling t-shirts under a particular name, you might have some amount of common law rights in that geographic region, but you're not going to be able to stop people in other geographic regions where you don't have prior activities from using the same or similar name. And so they're free. There's no application process. So on day one, you can legally put a TM if you're selling goods, or an SM if you're selling services, or you could also use a TM if you're doing services. But there's no application process in order to be able to put that little symbol next to any of your trademarks. If you're only doing business in one state, and you plan on having no out-of-state business, whether customers are coming to you or you're shipping or providing goods or services across state lines, if you're only going to be doing business in one state, you can get a state registration, which is going to cover you for that entire state. So it kind of broadens out a little bit those geographically limited rights that you would have through common law. You could have now statewide rights. But in this day and age, most people are providing goods and services across state lines. And so usually what people go for is what's called a federal trademark. And that's where you see the R in a circle next to a trademark. That's an assertion of federal trademark rights. And that is where there's an application process and a fee that you pay to the US Trademark Office. But once you obtain those rights, now that geographic scope of protection expands to cover the entire US and all US territories. And the only prerequisite to getting that registration is that you have to be doing business across state lines. So as long as you're doing business in at least one other state other than your own, you're now eligible to obtain that registration. And now you've got protection in all 50 states and all US territories. And you can even pursue, at least start the process of getting those rights before you even start doing business across state lines. And that's, again, something an attorney can work with you on. But that's typically what people go for, because it's just they're easier rights to enforce as compared to common law rights, and they're stronger rights. And they're broader rights, and there's a lot of benefits to going the federal registration route. So when you're at that point, I would highly encourage you to consider doing that, especially if you're in a business where there's probably nothing that you can get patents on or anything else. In those situations, that your business name is what sets you apart from competitors, and properly protecting that is the way to maintain that competitive advantage over your competitors. So there's again, similar to the patent stuff, there's ways of filing international or foreign trademark applications to get rights in other countries. So here's just a little information on that, but in the interest of time, we'll just kind of skip over those slides. So moving on to copyrights now. So copyright is even simpler than patents and trademarks. A copyright is just, as I mentioned before, it protects creative expression. So the second that you put pen to paper, or take a picture, or record a song, or create some sculpture, etc. Anytime you create a creative expression and place it into a tangible medium, you automatically have copyright protection in those creative expressions, in those works. However, and I think I mentioned this on the next slide, in order to have enforceable rights, so you have those rights automatically once you create a work, but in order to have enforceable rights, you actually have to file a copyright application with the U.S. Copyright Office, which we'll get into in a second here. But again, what these protections are limited to are these creative expressions. So it's not, it doesn't protect the any underlying ideas or concepts within those expressions, but just the expressions themselves. So take, for example, like a recipe book. If you have a recipe book and it obviously it's got, let's just say, food related recipes in it, you could protect that entire book as a copyright. It's because you've come up with this creative arrangement of the recipes, and the recipes themselves were presumably written in your own words, and all that, such that then getting a copyright on that recipe book is going to prevent other people from making unauthorized copies of the book itself. What it does not protect are the underlying recipes described in the book, meaning that if you have a copyright on this recipe book, you're not able to stop somebody from making that recipe. That's something where if you had a patent on the recipe, then that's how you protect the concept of that recipe itself. But a copyright is just going to protect that specific creative expression of the recipe book. And that's kind of an example of the differences between copyright and patent. And again, that's something that an attorney can help work with you on as well, as far as identifying what is the best vehicle to use to protect a particular idea you've come up with. And so similar to patents, though, and even trademarks, is these copyrights are giving you this right to exclude, meaning that other people can't practice the work or make unauthorized copies of the work without your permission. Now, you'll see some exceptions, which we won't get into during this talk. Again, I'm happy to answer questions about any of these off the call or after the webinar, or during, if we have time for questions. But just for your information, I just wanted to list all these things here for you. And we won't get into the detail of the term of a copyright, because it depends on a number of different factors, but this is kind of the general rule as far as kind of the general measurement, if you will, of a copyright term, at least currently. So as I mentioned, there's no application process technically to acquire these copyrights, but if you want to have enforceable rights, if you want to be able to sue somebody for copyright infringement, you actually have to timely register these works, or at least register the works with the Copyright Office. And as I note here, timely registering the work gives you additional protections or benefits by way of being able to recover even more money from an accused infringer, assuming a court finds that they actually infringed your copyright. But the rule of thumb is to file these applications either before you actually go public with the work, or within 3 months from going public with the work. And doing that is considered timely. And then if you later sue someone for copyright infringement, you can recover what's called statutory damages. And it's this automatic damage award that can range anywhere from, currently it's like anywhere from $150 up to like $150,000 per work infringed, depending on how egregious the infringer's conduct was. But if you don't timely register the work, let's say that you publicly release it or display it or disclose it, more than 3 months go by, and then someone infringes that work, and now you go through the application process so that you can then have the ability to sue that individual, that infringer, for copyright infringement. In that scenario, all you can recover is monetary, or sorry, actual damages. In addition to getting what's called injunctive relief, you can get a court to say that they can't do that anymore. But as far as monetary damages go, you can get actual damages, or the actual dollar amount by which you've been damaged. And so in a case where, let's say it's a book that you're selling for $20, if someone makes one unauthorized copy of that book, then your actual damages are only $20, as opposed to if you had statutory damages, you can get a lot more than that in most cases. And so by timely registering these works, you actually are giving some teeth to your rights, so that when you send these cease and desist letters to accused infringers, they're going to be more likely to comply with your demands as compared to if you did not timely register the work. So unlike patents and trademarks, copyrights are more or less recognized around the world through what's called the Berne Convention. So you don't have to go through this separate registration process in each country where you want to have enforceable rights. And again, that's something we can speak more about offline. Let's see. So moving on to trade secrets then. This is even simpler than the other three. A trade secret is, as I mentioned before, any information that derives independent economic value from not being generally known to others. What the key requirement is that you're taking reasonable measures under the circumstances to maintain the secrecy of that information. So again, a common example would be something like the Coca-Cola recipe, where it's only known to a handful of people within the company, and it's protected as a trade secret. But other examples would be things like customer lists, or other like standard operating procedures, or methods that are performed internally within your company. Just any information. It could even be certain aspects of your software source code that you don't publicly disclose. So those are common examples of what's typically protected as trade secrets. It is a limited cause of action, though, that you have as compared to like patents, where anybody that practices the invention without your permission would be deemed infringing your patent rights. But with trade secrets, the cause of action is limited to anybody that illegally obtains the information from you. So whether it's an employee that leaks the information outside the company, or somebody that hacks into your system and steals information that way, it's those types of activities that give rise to what's called trade secret misappropriation, where you can then go after them for stealing your trade secrets. But if someone's able to legally acquire the information, whether they buy one of your products and they're able to reverse engineer it, or if they just independently create the same thing, or independently develop that same information, those types of legal examples are not actionable as trade secret misappropriation. And so just something to weigh and discuss with an attorney as far as deciding whether you might want to try to protect something through patent protection or trade secret protection, is whether that information could even remain confidential, and for how long. And so there's no application process or cost to acquire these rights. You don't have to file an application with any organizing body to disclose what you're trying to claim as a trade secret. But you're still spending money as far as implementing what we would consider like a trade secret protection program. So you're typically paying an attorney, let's say, to prepare your employment agreements and confidentiality agreements and things like that, or you're paying an IT company to make sure that you've got proper firewalls and password protection in place on your computer systems. And those are the types of costs that come up when it comes to protecting trade secrets. So the term of a trade secret lasts for as long as the information remains secret. So again, the Coca-Cola recipe has been around for decades, and it will continue to be a trade secret as long as it remains confidential. But the second the cat's out of the bag, there is no more trade secret protection. So in other words, if someone figures out the Coca-Cola recipe and posts it online, anyone can then use that recipe, and Coca-Cola wouldn't have any action against anybody unless somebody illegally obtained that information at the outset, and then they could go after those entities or individuals. But again, so that's part of determining whether you go for patent protection or trade secret protection on a particular idea you have is we just kind of help you figure out what's going to provide the most bang for your buck, so to speak, because patents have a limited term, but the rights tend to be broader. But not everything's patentable. So in some cases, trade secret's better, but then we also want to make sure that you're going to be able to maintain that confidentiality long term. And so again, all conversations to have with your attorney. So just real quick, IP ownership. These are kind of the default rules, which is why I say absent a written agreement to the contrary, because parties can agree upon whatever they want as long as it's not illegal. So if you have a written agreement as far as who's going to own what, that would control the situation. But if there is no written agreement, these are the default rules that courts tend to apply. And the most important one, the one I'll touch on is for patents, where the default rule is that each individual inventor has an equal undivided ownership interest, and there's no profit sharing obligations to any co-inventors. So what that means is that if you and a friend develop something, if there's no written agreement between you as far as who's going to own what, the default is that each of you will be equal owners of that invention. So if hypothetically you later have a falling out and you go your separate ways, there's nothing stopping each of you from spinning off your own companies around that technology and profiting on it and basically competing with each other and not having to share any profits between the two of you. And so my advice is always, if you're in any business with more than just yourself, there should be written agreements in place where anything that's developed by all of you is assigned over to the company itself. So meaning that you would want to have like an LLC or a corporation or some other formal business entity in place. And then it would be that business entity that owns all of this IP. That way, if you do have a falling out with anybody, if they exit your company, they're not able to take any of that IP with them. Now, obviously, there's going to be agreements like the operating agreement that's probably going to require you to buy out their share, or whatever your operating agreement says as far as what happens when someone leaves the company. But so you would have to comply with those contractual requirements, but they're not going to be able to take that IP with them. And so you're able to avoid those situations by having the business entity be the owner. And again, that can all be done in writing, and it's should be done. But if not, then these are the default rules. Some other things to remember: just because you pay to have something created does not automatically mean that you own that creation. So again, this is another example where you want to have these things in writing. So if you hire an employee or an independent contractor, there needs to be a written agreement with that individual. That's in part of that written agreement, including like what are their rights and obligations, what's the pay rate and all that kind of stuff. There should also be language in there that talks about anything they create, they agree to transfer over to you as the employer, so that all ownership goes to you with respect to anything they create. If you don't have that kind of written agreement in place, then it really just depends on what jurisdiction or what court you're in as far as who's going to be deemed the owner. And so some courts would still say that you as the employer would be the owner, but there are other courts that would say that you just have what's called shop rights, meaning that whoever created the we'll just call it the IP, is the owner, and you have a license to commercialize, typically a non-exclusive license to commercialize that IP. But there's nothing stopping the creator of the work then from monetizing it themselves or selling or licensing it to your competitors. And so there's just a whole list of issues that could come up if you don't have these things properly documented or covered in a written contract. So just don't fall victim to that and assume that if you pay someone for something that you own what they create, because that's not always the case. You always want to get it in writing. So this kind of just touches on what I just said. That you may have heard the phrase "work made for hire." Again, that's something, as I say here, that I advise against using. It's a very narrowly construed term, and it only applies to a subset of copyright situations. But anything else is not considered a work made for hire when it comes to independent contractors. And so the way to get around that is just to use what's called an assignment rather than this work made for hire language. And by doing that, you're able to avoid these potential issues of the independent contractor retaining any kind of ownership in what they create for you. So again, just get these agreements in writing and preferably reviewed by an attorney, if not prepared by an attorney. And you want to get these things done at the outset before the work's actually performed. That way you don't have to worry about them not agreeing to sign something after the fact or trying to negotiate the terms. Just get this stuff all in writing right at the outset, and then you don't have to worry about these issues. So this slide just kind of gives examples of how IP is typically monetized. In the interest of time, I'll just leave it to you to kind of read through it. Again, I'm happy to answer questions about any of this, but it's in short, it's just you either take a product to market yourself through direct commercialization. You can license, basically letting someone else take the product to market for you, and they pay you a royalty. You can sell the IP outright so that someone can then take the product to market. Or you can make money by suing other people who are infringing your intellectual property rights. Those are the four main ways that people monetize IP. So 5 common startup mistakes. First, and probably one of the biggest ones, is not having proper and documented chain of title. So when you're developing things, especially if you're going to be at any point selling your business or trying to bring on investors, you want to have proper chain of title for all your IP, meaning that you've got appropriate written agreements in place with any of your employees and independent contractors that has this language in it that says anything they create belongs to you, the employer. And you also want to make sure that none of your employees or contractors or partners have any obligations to prior employers. So oftentimes when someone's starting a new business, it tends to be somewhat related to their current business that whoever they're working for. And if that's the case, you want to make sure that there's no obligations in your current employment agreement that say like anything that you create while you're employed by this company belongs to your employer. And so it's just something where you could have an attorney review your current employment agreement to make sure there's none of these types of obligations, because the worst thing would be to spend a bunch of money trying to start a business and protect all this IP, and then later come to find that your employer has an ownership claim over some or all of it. So so it just, yeah, make sure you've got all the chain of title issues figured out right at the outset. So you don't have to worry about those headaches down the road. And again, if you don't have that chain of title, if you're trying to fundraise, I mean, one of the first things investors will do as part of their due diligence is they will ask for all this chain of title documentation. And if you don't have it, now you're scrambling trying to get it. And I mean, depending on how long ago some of the stuff was created, if some of your employees are no longer with you, now you're having to track them down to try to get them to sign things after the fact. And it's just, it could be a real nightmare. So just having this stuff done right at the outset is going to avoid all that headache and all those potential issues. Another common startup mistake is as we kind of already talked about, publicly disclosing or commercializing products or services before you file your patent application. So again, have that conversation right at the outset so that you're not cutting yourself off from being able to pursue patents on what you're developing or what you've developed. Another common mistake is relying on a patent application that lacks sufficient detail. We didn't really get into that during this conversation, but that kind of factors into when people try to file their own provisional applications. And again, I just kind of have some tips right here as far as if that's going to be something you try to do. And I'm happy to have those conversations offline if you're looking to try to file your own provisional application. And then the last two are just basically go to that freedom to operate issue, where if you don't do that kind of initial searching to make sure that you have the right to use or the ability to use whatever trademarks you want to use, or the ability to sell whatever products or services you want to sell, that could be problematic, because then you're going to get hit with the cease and desist letter potentially, and now you're trying to rebrand or redesign your products and do other things to try to no longer infringe and also deal with that infringement claim. And again, better just to do that research right at the outset before you go to market. That way, if we do identify any potential issues, you can make any changes necessary before going to market and avoiding those cease and desist issues. And so here's some questions and this kind of touches on everything that we've gone over today. And I will provide this as a handout as well that Philip can distribute. But these are questions just to keep in mind as you're working on developing a new product or a new business. And again, these aren't questions that you're expected to answer on your own, but these are questions that you should be answering with the help of an attorney to make sure you're doing everything properly and that nothing's falling through the cracks, and that you're considering all of your options. And you'll see here, I note that are any aspects worth protecting? Because you might have a lot of different IP assets in your business, but not all of them might be worth spending the time and money to protect. And so having these conversations with an attorney can help you prioritize and figure out, okay, what's actually worth pursuing and what's just worth, just going to market with and not worrying about spending any time or money to protect it. And then this last one, how can I monetize my IP? It's definitely a question that's worth asking right at the outset. I'm sure you've heard the saying, it's always best to start with the end in mind. And every company is going to have an exit at some point, whether you pass away and the business passes on to your heirs, or you sell the business at some point. And so planning for that potential exit is always good, because it helps you then determine what's the best path to go down. So for example, if you're just looking to take this product to market yourself, but you want to keep open the option of let's say licensing, or maybe you're looking to just license right out of the gate. You don't want to take the product to market yourself. Those would be situations where filing patent applications and trademark applications could be more beneficial, because you want to build that portfolio to make your company look more attractive to someone that might come in and acquire you or license your trademarks or your technology. And so just thinking about what you're potentially open to would help you then kind of plan accordingly. And so starting with the end in mind is always advisable. So yeah, that's all I've got. And I know I covered a lot. And like I said, I'm happy to answer questions. This is my direct line and my email address. And again, Philip will distribute the slides and that question handout. So you'll have all that. And so if at any point you have any questions about anything I've covered today or anything specific to your business or what you're working on, I'm always happy to answer those questions and have those conversations.